தருணிகா ஸ்டார்ட் பண்ணுங்க.
Good morning. Write it, shoot it, publish it. Whatever, make it. Agree with this above quote. I take this golden opportunity to welcome everyone to this delightful session on intellectual property rights with focus on copyright and patent. Today we have Dr. S. Gopinath sir, Professor and Head in Department of Electronic Communication Engineering, Kapagam Institute of Technology. It's a pleasure for all of us to have such a great personality among us. We all are keen to hear from you, sir. It's a honor for me to welcome you, sir. I welcome you behalf of the management, the principal, the vice principal, all the faculty members, and the students taken part. And I heartily welcome our coordinator, Mrs. V. Pavitra ma'am, Assistant Professor in Department of Electronic Communication Engineering, Kapagam Institute of Technology. I also take this opportunity to welcome the participants to the session. Though this webinar we can learn the intellectual property rights. I ensure you all that you will thoroughly enjoy the session of the webinar and definitely take some learning home today. Once again, I welcome you to this webinar, sir. I call upon Dr. S. Gopinath, sir, to take over the session.
Am I audible?
Yes, sir.
So thank you, Dharmika, and thank you, Pavitra ma'am, for inviting me to deliver this session. Um, I hope you may have understood about. I think you may have an overview on intellectual property rights, right? So intellectual property right. So it is the right given to a person for their creation. Okay. If you say in Tamil, அறிவு சார் சொத்துரிமை. Okay. So what you are going to develop, it may be a product or it may be a process or it may be a tool, it may be apparatus, it may be a methodology or whatever it may be. So based on your idea or creativity, you are going to invent a product. You are going to make a product. So for that product, so before it comes to the market, first you have to make a rights that is applicable to you only. That is the owner only. The owner means those who are going to create a product, okay, invent a product. So the right given to a person for their creation, for their idea, for their process, it is known as intellectual property rights. ஓகே ஸோ இன்டெலெக்சுவல் மீன்ஸ் இன்டெலெக்ட் மீன்ஸ் தமிழில் சொல்றது பார்த்தீங்கன்னா உங்களுக்கு அறிவு அப்படின்னு சொல்லுவோம். ஓகே ஸோ ப்ராப்பர்ட்டி மீன்ஸ் சொத்து, தமிழில் பார்த்தீங்கன்னா சொத்துன்னு சொல்லுவோம். ஓகே ரைட்ஸுங்கிறது பார்த்தீங்கன்னா உரிமை. தட் இஸ் இன்டெலெக்சுவல் ப்ராப்பர்ட்டி ரைட், அறிவுசார் சொத்து. So today I am going to give you the just overview of intellectual property rights. What is mean by IPR? What are the different IPRs available in India? Okay, what are the categories? How we can search a patent in a website before if you are going to file a patent? Okay, that thing we will discuss today. So intellectual property rights will focus on copyright and patent. So particularly we are going to focus on this major two topics, that is copyright and patent. And apart from that also we will discuss another topics, different categories of intellectual property. Okay. So intellectual property right, I already told you that it is the right given to a person for their creativity. Okay. Suppose if you have an idea to develop a product. So in order to develop a product means first you have to think about the idea for inventing a product. Okay. For a product வேணும்னா first you have to think about it. How the product will be, what will be the outcome of the product. Okay. What will be the income to the product. Okay. What will be the expenditure. Everything you have to manipulate before you are going to invent a product. Okay. So first of all you should have that idea. So that idea should be converted into a patent, that is IPR. Okay. So first you have to make a rights of that idea. Okay. After that only you can design a product, or you can develop a product, or you can design a methodology or process or whatever it is. Okay. So based on your creativity, your idea, your process or method, whatever you have designed from your own mind, from your from your own intellect, that is called the intellectual property right. The right given to your creativity. Okay, that is called the intellectual property rights. Okay, so intellectual property is a property that arises from human intellect. Okay, suppose if you are going to design an electronic product, okay, that will be useful to the society or social need, okay, or for emergency application or for healthcare application, you are going to design the product. Okay, first you should have that idea for designing a product. That idea should be patentable. That idea should be patented before it comes to a it comes as a product into the product into the market. Okay. So this is what about the intellectual property. Okay. So generally there are two types of property. One is tangible property and another one is intangible property. So what is the meaning of tangible property? The property which is touchable one. The property which can be used by the owner, which can be used by the uh, property of the owner or inventor or applicant, whatever it may be. Okay. So the property which is the touchable one, that is called the tangible property. The property which is untouchable one, that is called the intangible property. Okay, so tangible property means if you take an example like land, house, estate, car, okay, buildings, whatever it may be, these things can be used by the owner. Okay, by through the we can use this, we can use it for the daily purpose. Okay, that is the tangible property. If you take the intangible property, it is invisible one. Okay, it is the invisible one, or it may be untouchable. Okay, so your idea is totally untouchable. Your bank account is not untouchable. Okay, your bond is not untouchable. Your life is not untouchable. Okay, so these are all coming under the intangible property. That is called the intellectual property. Okay, all the intangible properties are coming under the intellectual property. That means it based on our creativity or idea, which should be totally untouchable one. Okay, that is called as the intangible property. Okay. So next one is why IP protection is given. Why we need to protect the IP, intellectual property. Suppose if you are not protecting your IP, you have an idea. Suppose if you are sharing your ideas with your neighbor, with your friend or your colleague, okay, using your ideas, he can make a product. He can sell a product into the market and he can gain the profit. So many things may happen from your idea. If you are not protecting your idea or your idea under the intellectual property rights. Okay, these are all things may happen. Okay, so that is why we need to protect the IP. Okay, so once we have protected, what are the advantages of IP protection? Means capital expenditure for new product. You can gain the revenue from that product for selling a product into the market, or you can use it in the research and development purpose, or you can use it for the through the marketing and advertisement for selling your product. There will be no freeloaders here, and you can also maintain the loyal follower. Suppose your product is good, it is compact, okay, it satisfies all the criteria to the user, those who are using your product, okay, based on the cost wise, based on the compactness wise, based on the usage, okay. So these things coming under the loyal followers. Now, definitely the followers, definitely the customers will able to buy your product. Okay, they may forward your product to others. Okay, and you can expand your product selling to the market. Okay, into the market, and finally you can attain the more profit. You can gain the more profit or revenue from by selling the product. Okay, so this are all coming under the IP protection features. Once you have protected your IP, okay, so first you have an idea. Once the idea is protected by the intellectual property right, so from the idea you can make it as a product or you can develop as a product. And once our product is ready, you can sell it into the market by marketing, by advertisement. Okay, so or you can use your idea in the research and development process for making a product. Once your product is good or compactness, definitely the loyal followers will be more for utilizing your product. Okay, from that you can gain more revenue from the selling your product. Okay, so these are the features of IP protection. It is compulsorily required. Suppose if you have an idea for making it a product, okay, so then only you can gain. Okay, you can receive more outcome from that. Okay, so intellectual property as a property, okay, it can be sold. Once you have filed your IP, okay, it can be sold to some other person. You can also sell it to your friend or neighbor. Okay, suppose if you are not, if you don't have enough investment with you, okay, so if you don't have enough investment, suppose your friend is having that much investment for making a product from your own idea, you can also sell it to him. Okay, that is possible in the IP. You can also transfer the idea from your name to your friend name for converting your idea into a product. Okay, and you can also buy from others. You can also sell it or you can also buy it from others. Okay, suppose if you have enough investment for converting your idea, for converting your friend idea or colleague idea or your neighbor. Okay, if you have sufficient investment for making it a product from your colleague idea or your friend idea, okay, you can also buy it from them. Okay, that is also possible from the IP. It can be given as a lease or rent. Okay, so it can also given as a lease for 2 years or 3 years or 5 years. Okay, actually the IP protection is valid for 20 years. After 20 years, it will be coming into the public domain. Okay, anybody can use your idea, anybody can use your process, anybody can use your methodology and make it as a product and sell it to the market. Okay, so it can pass under a way. We can also pass it to some other person, or it can be assigned to some other person. Okay, so these are the few advantages of IP protection. IP, once you have filed as a patent or a copyright or a trademark or a trade design or whatever IP are available, it can be sold or it can be sold, it can be bought, it can be given as a lease or rent. Okay, or it can be assigned to some other. Okay, so this is what about the IP as a property. Next one, what are the different categories of intellectual property rights? Okay, so there are two major categories. One is industrial properties and another one is copyright. So industrial properties, these things are coming under the industrial properties. First one is patent, second one is industrial design, third one is trademark, fourth one is trade secret, and fifth one is geographical indication. We will see one by one. Okay, and another one is copyright. Okay, so copyright is given to the person, those who wrote a poem, those who wrote a novel, okay, those who developed an algorithm, okay, those who have done a painting, okay, so that can be copyrighted. Music, that means songs can be copyrighted, algorithms can be copyrighted, books can be copyrighted, poems can be copyrighted, or novel can be copyrighted. Okay, so these are all paintings can be copyrighted. Okay, so all the things are coming under the copyright. Okay, but if you take it as an industrial property, the first one is the patent. Patent means the thing that is idea can be patentable. Okay, process can be patentable, product can be patentable. Okay, methodology can be patentable, and if you have an invention or innovation idea for creativity, that can be patentable. Composition of matter can be patentable. Okay, these are all coming under the patents. So the patent is valid for 20 years. Okay, so patent is an intellectual property right. It is a right given to a person for his innovation, that is product, process, methodology, or idea. These things coming under the patent. Okay. Suppose if you are going to do the final year project or any project, okay. So first you have to search a patent, whether it is already existed in the market or already implemented in the market. First you have to search a patent in the patent search tool. After that only you will be able to file a patent in the patent office. Okay. So the process can be patentable. Your idea can be patentable. Suppose if you have developed a product, okay, so from an existing tools, okay, the product is new to the market. Nobody were utilized your methodology or nobody were utilized your process, okay, your idea, your innovation or your creativity. Okay, that thing can be patentable. Okay. And industrial design. So industrial design means design. That is, suppose if you have developed a product, the product appearance of the product. Okay, the appearance of the product is totally distinctive from others. Okay, suppose if you have developed a water bottle. Okay, so the water bottle design is totally different from others. That is called the industrial design. Okay, the appearance of the bottle is totally different. It looks very shiny, or it looks very beautiful, or it is totally admired by the customers. Okay, that is coming under the industrial design. Trademark. Trademark is based on the availability of the product, that is the usage of the product, applicable in the and publicly sell it into the market. Okay, that is coming under the trademark. Okay, the trademark may be in the form of logos, in the form of words, in the form of sentence, in the form of some name. Okay, that is coming under the trademark. Okay, the symbol of the trademark will be TM. Okay, and trade secret. Secret means the secret should be confident. It should not be revealed to anybody. Okay, suppose if you are running your business, okay, totally 100 employees are there. You are maintaining the 100 employees database in your organization. Okay, you have put a you have protected the database through the password. The password should not be open to all the persons. Okay, that is coming in the trade secret. Okay, and last one is geographical indications. So this is based on your product from your own geographical region. Okay, so geographically indicate the major location of the main location of the filing the geographical patent is in Chennai, available in the Chennai. Okay, so suppose if you have developed your product from your own geographical area, okay, so the product specification, the product quality is totally different from others. Okay, different from other products. So that is coming under the geographical indication. Okay. So next one, what are the laws? When the laws were adapted in India, okay, when it was adapted for protecting the intellectual property. So first one is the Copyright Act. It was adapted in 1987. Trademark Act. It was adapted in 1976. Patent Act. It was adapted in 1970. And Industrial Design Act 1996 and Geography Indication Act 2000. Okay. So first we will look into the patent. Okay, patent I already told you that it is the exclusive right which is given to the inventor or a owner for a product for his process, granted by the government for the limited period. The period will be around 20 years. Okay, in order to avoid, okay, avoid somebody is going to use your idea for selling the product into the market. Okay, so for that purpose only the patent was initiated. Okay, so the patent, um, date availability date for this patent is 20 years from the date of file. Validity will be around 20 years from the date of file. Okay. So suppose நீங்க ஒரு ப்ராடக்ட் கிரியேட் பண்ணிருக்கீங்க, ஒரு ப்ராசஸ் வச்சிருக்கீங்க, ஒரு ஐடியா வச்சிருக்கீங்க, ஒரு மெத்தடாலஜி கிரியேட் பண்ணிருக்கீங்க ஃபார் கிரியேட்டிங் ஃபார் டிசைனிங் a product or developing a product. Okay. So our composition of matter. Okay. These things can be patentable. Okay. Where are the patent jurisdictions available in India? Means four major states. One is four major places. One is Mumbai, and second one is Chennai, third one is New Delhi, and fourth one is Kolkata. So these are the patent office branches. Suppose if you are going to file, these are the national level patents. Okay. Suppose if you are filed in the international level patent, means that you can approach the WIPO. WIPO is the International Patent Organization. It was located in Geneva, Switzerland. Okay, particularly for promoting the protection of the intellectual property throughout the world. Suppose if you are going to file an international level patent, means you can approach the WIPO. It was adopted in 1967 in Geneva, Switzerland. And Patent Cooperation Treaty. Okay, it is also the another organization for protecting the intellectual property rights. It was located in USA. It was adopted in 1970. And third one is World Trade Organization. Okay, suppose if you are doing the trading market, okay, some kind of business, okay, suppose if you are going to promote your product in international level, there you can approach the World Trade Organization. It was located in Geneva, Switzerland. It was adopted in 1995. So these, that is WIPO, Patent Cooperation Treaty, and World Trade Organization, all the three organizations, particularly for filing your patent or promoting your trade in international level. Okay. So suppose if you are going to file the national level patent in inside the India, there you can approach major four places. One is Mumbai, Chennai, New Delhi, and Kolkata. For us, we have to file a patent in Chennai Patent Office. Okay, you can do the patent filing in online mode or offline mode. Okay, there are two modes are possible in filing a patent. Okay, that is online and offline mode. What are the things can be patentable? That is, I already told you that product can be patentable. Suppose if you have developed a product, the product is useful to the society. The product is useful to the social needs. The product is useful to the useful in the medical purpose or healthcare purpose. Okay, these things can be patentable. Okay, okay. And next one is tools, apparatus for producing the product. Suppose if you have not developed any product, you have no tools, you have an apparatus, you have an equipment for producing the pattern. Okay, that you have some sketch, okay, layout or idea. Okay, that can be useful for producing the product. Okay, that things can also be planned. And next one is process. Process means you know the process, how to develop a product. Okay, you know the process. Okay, just you have the process or idea, that things can also be planned. Composition of matter. Okay, what are the things can be included for developing a product? Okay, that is coming under the composition of matter. These things can also be patentable. And finally, methodology. Okay, methodology is also patentable. Okay, you know the methodology. Block diagrams, have some block diagrams, we have some circuit diagrams, we have some methods, illustration. Okay, some kind of sketching you have for developing a product. That can also be possible that can also be patentable in India. Okay, so these are the major 5 things can be patentable in India. Okay, what are the major documents required for filing a patent? So Form 1, Form 2, Form 3. Major 3 forms are required. That is application form, specific design or features that you have to put in the Form 2. And another one is the undertaking section is required. That is Form 3. And drawing and other kind of power of authority is also required for filing a patent. So this is what about patent and what are the things can be patentable. Okay, what are the major documents are required for filing a patent. Okay. And next one, next we move to the trade secret. It is another kind of intellectual property right. Trade secret, I already told you that. Suppose if you are running a business, okay, you are going to running a business, okay. So you are maintaining the client list and the employee list, okay, which is totally protected by the password, okay. So that things is not revealed to anybody, okay. This is coming under the trade secret. Whereas either trade secret is patentable means no, it is not required. You can maintain yourself. You can maintain with your organization itself. That is enough. Okay. Suppose if you are maintaining your employee data. Suppose if you are maintaining your client list. Suppose if you are maintaining your product information that can be secretly maintained by protecting a computer password. It is not required for, there is no requirement of patent here. Okay, there is no requirement of registration under the government for trade secret. Okay, you can keep it yourself. That is coming under the trade secret. Okay, I can give you the example for trade secret that is, you already know that it is very familiar in the market. That is Coca-Cola. It is a soft drink. It was invented in 1886. Actually, it was never protected by the patent, only by the trademark and trade secret. Trademark means the Coca-Cola name. Okay, so how the name is given, how the trademark is given to the particular product name. Okay, the product name and product specification is it is not totally related to each other. Okay, so that if you look at the soft drink and Coca-Cola, the name Coca-Cola, it is not totally related to each other. Coca-Cola is different, soft drink is different, but they have put a name that is Coca-Cola for the soft drink. Okay, so that is coming under the trademark. That is the name and the product future is not totally related to each other. That is coming under the trademark. Okay, and next one is the trade secret. What is the secret maintained in the Coca-Cola means the taste of these soft drinks. It is totally different from other. Okay, if you take Pepsi, and the Pepsi taste and Coca-Cola taste is totally different from each other. Pepsi is the competitor of the Coca-Cola, but still now they have not competed the Coca-Cola soft drink because they have used some secret for producing this soft drink taste. Okay, if you know, in the Coca-Cola company, only two persons know the secret of Coca-Cola soft drink, and nobody knows this secret of soft drink of Coca-Cola taste. Okay, only the two persons were known about the taste of the Coca-Cola soft drink, where they are not allowed to go anywhere else. Okay, anywhere else. Okay, only the two persons they are not allowed to travel together. Okay, suppose if anyone, both of them died. Okay, the secrecy will not be revealed to the other party. Okay, that is the advantage of the trade secret used in the Coca-Cola. Okay, only the two persons knows the formula of Coca-Cola soft drink. Okay, that is coming under the trade secret. Okay, Coca-Cola have both trademark as well as the trade secret. Okay, and next intellectual property rights is the copyright. Copyright, you already know that. Okay, that is any literary work, film work, artistic work, drawing, photographs, art, sculpture, software. Okay, algorithms. Okay, so in our EC department, we can, if you are doing a mini project or a final project, that thing can be patentable. But if you are doing the computer science and the engineering department, suppose if you have developed any project, software project or algorithm or any application app or any web kind of application, that things can be copyrighted. Okay, it is not patentable one because it is not a process, it is not a product, it is not a methodology. It is an algorithm. It is a code. Okay, it is a document. It is a document. That things can be copyrighted, not patented in India, particularly in India. But if you take USA, United States of America, Okay, that the algorithms and software can be patentable. That is, that can be patentable in USA. But if you take in India, the software algorithms cannot be patentable, but it can be copyrighted. Okay, so the copyright is exclusive right which is given to the authorized person to do some certain actions in relation. Suppose if you want to reproduce the material, if you want to reproduce the algorithm, or if you want to reproduce the software, you have to make a copyright for reproduction of this copyrighted material. Okay. Suppose if you have written a novel, if you have written a poet, if you have written a book, or if you have done a painting or any kind of software related project, that can be copyrighted. Okay. Suppose if somebody is going to upgrade your software, upgrade your algorithm, or modify your algorithm, they have to get a permission from you because you have already copyrighted that algorithm or software. Okay, so before they are going to make some changes or they are going to make some upgradation in your project or in your software, in your algorithm, okay, they have to get a permission, prior permission from you. After that one day, they may able to allow to do the some certain access information. So these are all coming under the copyrights. Okay. So what is the validity of copyright means 60 years. Author's life plus 60 years. Okay. You know the music director Ilayaraja. Okay. He is still now getting the remunerations or some kind of corporate allowance from his songs. Okay, wherever they are playing all the rights given to the Ilayaraja for his composed music. Okay, his life plus 60 years. After his life, okay, 60 years is validity. Okay, 60 years validity after his life. Okay, suppose films or photographs or music composition, everything is possible. Suppose if they are going for the broadcasting any kind of film that is available for validity of 25 years. Mainly the copyright protects the publication of studies and another examples are drug companies may also do the copyright for their invention. Okay, they are coming under the copyright laws only. And books, paintings, musical composition. Okay, so it is already posted in this previous slide. Okay, so radio, TV programs, movies, everything coming under the copyright. And next one is the geographical indication. So this is another kind of intellectual property where it should have a if you have a product, okay, the product should have some quality, some special features, some characteristics, or some reputation based on the climatic or based on your geographical location. It should be very unique. Okay, so the best example is Kanjipuram silk, Darjeeling tea. Okay, so in April 2019 in Tamil Nadu, Nilagiri tea, Nilagiri tea approved for the under the geographical indication and Kovilpatti candy, that is Kovilpatti Kadalamittai. It is also coming under the geographical indications and the Kanjipuram silk. Okay, and so many things were approved under the geographical indication in Tamil Nadu. Okay, because the product or some kind of the product will have some quality which is unique. Okay, based on their own geographical indication. Okay, based on its reputation, then only it will be given to this particular product. Okay, so what will be the validity means? The validity will be around 10 years. We can also make it as go for the renewal process for another 10 years. Okay, so that is also available in the geographical indication. What are the benefits? Benefits means we can protect the product from unauthorized reuse. We can boost the rural development purpose. We can also reproduce the unfair practice of trade, and we can also preserve the local culture and resources. As of now, in India, up to 2019, we have around 344 geographical indicated product. That is approved product is around 344.
Okay. So now if we look into these what are the major geography indicators that is illustrated in the picture. Okay. Based on the climatic condition, based on the geographical location, and based on the unique feature of the product or special quality of the product or characteristics of the product or reputation of the product. Okay. So based on the product, okay, from the location, okay, it should have some special quality, then only the geographical indications will be provided to the particular product. Okay. So Tirupati Laddu, the taste of the Tirupati Laddu is totally different from other laddus which is manufactured in India. The taste and quality and features and reputation of the product goes to these, okay, it is totally coming under the geographical indications. Okay. So this is what about GI. And next one is the industrial design. Okay. So the design mainly focusing on the appearance of the article, not how it works. Okay, the process, okay, and its outcome is not required, but the appearance, say in terms of t-shirts, shirt, okay, or design of bottles or design of product. The appearance of the product is totally different or totally distinctive from other product. Okay, that the industrial design plays. Okay, that the industrial design speaks. Okay, so the industrial design registration products designs having industrial or commercial purpose. It may be in terms of stamps or labels or tokens. Okay, fonts or cartoons, whatever it may be. The appearance is given coming under the industrial design. The validity of the industrial design is around 10 years and it can be extended up to 5 years. Okay, we can make a renewal for another 5 years also. That is coming under the industrial design. So the industrial design is basically focused on the appearance of the particular article or appearance of the particular product, not for its working. Okay, particularly the appearance, the looks. Okay, so that is coming under the industrial design. And next one is the trademark. Trademark, it may be in the form of logos, in the form of words, in the form of pictures, or combination of words, logos, and pictures. Okay, that is coming under the trademark. It is totally the goods, particularly for the particular goods. Okay, so if you look at this picture here, okay, I'm just going to maximize the picture here. Okay, so here you can see the Coca-Cola, Vodafone, Facebook, Ford, that is a car company, IBM, software company, HP, okay, Orange Bus, okay. So these are all coming under the trademark. And WhatsApp, the logo, okay. The logo is totally distinctive from other goods, okay. This is the Android, okay. So the Android logo is totally different, okay. It is new to the market, okay. So that is coming under the trademark. So it may be in the form of words or in the form of logos or in the form of in the combination of both logos and words. Okay, that is coming under the trademark. Okay, so நம்ம t-shirt பார்க்கறதா இருந்தாலுமே பாத்தீங்கன்னா மெயினா பாத்தீங்கன்னா trademark. Okay, so ஒரு ப்ராடக்ட் வாங்குறோம், அந்த ப்ராடக்டோட நேம், ஓகே, அந்த ப்ராடக்டோட சம் ஸ்பெசிபிக் ஃபீச்சர்ஸ் வச்சு தான் நம்ம என்ன பண்ணோம், we are going to buy it. That is coming under the trademark. Okay, so the trademark is illustrated as the T-M. Trademark is illustrated as T-M. Okay, but the trademark is particularly given to the particular goods where I already told you that the Coca-Cola, the name is totally different from its soft drink. Okay, it is not totally related to each other. Okay, soft drink is totally different and Coca-Cola name is totally different, but we are going to name it as a Coca-Cola for the particular soft drink. Okay, so that the trademark speaks. Okay, the trademark is given to the particular product, the product name, the product logo, but the product the product usage or particular product outcome is not totally related to the product name. Okay, ஸோ கொக்கோ கோலாங்கிறது பார்த்தீங்கன்னா உனக்கு நேமே புதுசாக இருக்குது, இது எங்கேயுமே நம்ம வந்து ஐடென்டிஃபை பண்ணவே முடியாது. சேம் டெர்ம்ஸ் ஆஃப் ரிலையன்ஸ் பார்த்தீங்கன்னா டோட்டலாக ரிலையன்ஸோட கம்பெனியில் மட்டும் பார்த்தீங்கன்னா there are around 250 trademarks they have registered. 250 trademark registered under the Reliance. Okay? The name is totally different from the product. It is not totally related to each other. Okay. So IBM and Android, the symbol is totally different from the software application. And WhatsApp logo is totally different from the software application. Okay, web application. Okay, so the name and its product is not related to each other. That the trademark is given to the particular product. Okay, so the validity of the trademark is around 10 years. Okay, 10 years of the validity. Okay, once it is registered, the symbol is denoted as R. Okay, suppose if someone is going to apply for the trademark, that they can put a symbol like TM. For applying the trademark, the symbol will be TM. Once you have registered your trademark, the symbol will be R. Okay, so the validity will be around 10 years. Okay, and whether trademark can be registered or not registered. Okay, so particularly for certain actions of identifying the quality and trade connection, we can go for the trademark. So this is what about the intellectual property rights. Okay, that a patent, second one is copyright, third one is geographical indication, trade design, trade secret, and trademark. Okay, these are all coming under the intellectual property rights. Okay, so we can look at glance about that different kind of categories of IPR. First one is property, that can be given as a right. Suppose if you have an idea that is converted into an expression like a book, music, okay, painting, sculpture work, that can be copyrighted. Suppose if you have an idea, suppose if you are going for innovation on invention, inventing a product, that can be patentable. Idea can be patentable, innovation can be patentable, invention also can be patentable. Okay. Now, if you have an idea, okay, you have a quality and identity. Okay, suppose if you are going to file coming under the trademark, and you have an idea, okay, that will be converted into a product. The appearance of the product is coming under the trade design or industrial design. You have an idea, okay. Just suppose if you are running a business or any kind of organization, you are going to keep it as a secret, confidential of employer information and client information. It will not be disclosed to anybody. That is coming under the trade secret, whereas trade secret is not required for the registration. Okay, we don't need to register the trade secret. Okay, so but the trademark, patent, design, copyright, these things should be registered, but the trade secret is not required for the registration. Okay, these are the different categories of the industrial property rights. Okay, I hope you might have understood about the overview of intellectual property rights and other categories of intellectual property rights. Okay, and now we are going to look into the patent search. What are the different types of patent search tools available in website? Okay, so suppose if you have an idea, if you have a product, or if you have a process, if you have some methodology, okay, before you are going to file a patent, first you have to search a patent that is in the market or already.
Okay, so using these different kind of search options, you can do the pattern search in the website. First one is text search, second one is simple search, third one is advanced search, fourth one is syntax, fifth one is number search, and last one is structure search. These are the different types of search options available in the website. Okay, before you are going to file a patent, you can do the different kind of searching here. Okay, what are the different types of patent search tools are available? Okay, whether you can go through the paid search tools or you can use the free search tools for searching a patent before you are going to file a patent. Okay. So generally, you can prefer this first free search tool, that is ipindiaservices.gov.in/public search. Okay. So once you have entered into the link. Okay. There are different search options will be available, where I have already mentioned in the previous slide. Okay. Okay. Using this different search option, you can search the patent whether it is already existed in the market. Okay. So from that, you can come to the conclusion whether you can file a patent, or you can make some innovations, or you can make some upgradation in the existing product. Okay. After that, you can file a patent. Okay. And patent scope search, this is also a free search tool, JPO, IPTM, and VSP, app, FT. These are coming under the free search tool. Suppose if you want to go through the paid search tool, means you can use the Cascade Worldwide eSpace ent.com and micropattern and searchip.com. These are all coming under the paid search tools. Okay, better you can use this first one, that is ipindiaservices.gov.in. It is already free to the users, where you can search a patent at free of cost. Okay. So this is the web page of ipindiaservices.gov.in, where I already told you that different types of search options available. Okay, you can do different types of search. Okay, title search, abstract search, application number, patent number, structure search, and applicant name. Okay, you can do different kind of search options for searching a particular patent. Okay, and next one is infringement. Okay, suppose if anybody use your idea and make that idea into a product and sell that product into the market and gain some revenue. Okay, gain some revenue from the market from by selling the product into the market. Okay, that is coming under the infringement. Okay, if somebody wants to sell a product, if somebody wants to develop a product from your own idea, first you have to transfer the product from your name to their name. Okay, or you can given as a lease or rent to that particular name, particular person, those who want to sell a product into the market. After that only they may be allowed to, okay, they may be allowed to sell a product into the market and get a revenue from that. Okay, so suppose if anybody is misused your idea, okay, without informing you, without your knowledge, if they are going to develop the product and sell it from your own idea, means that will be coming under the infringement. Okay, so infringement of a patent occurs when a competitor makes users self-offer to sell or imports an embodiment of the invention without the permission of the patent owner. That means without you have already filed a patent. Okay, in the patent office, it is valid for 20 years. Okay, now the patent is available in the website. If somebody is going to look into your patent idea, okay, and process or your methodology, based on the methodology, he is going to develop the product and going to sell it into the market. Means if it comes to know, okay, if it comes to know, means that will be coming under the infringement. There are two types of infringement. One is direct infringement, and the second one is indirect infringement. Okay, so what are the major consequences of infringement? Means injunction. Okay, that means all your product may be removed from the market, and destruction of your product, paying damages to the patent owner, being sent to the imprisonment. Okay. Okay, these are the consequences of the infringement. Without your knowledge, without informing you, if somebody is going to sell your product, means that is coming under the infringement. The damages should be paid to you. Okay, and they may be sent to the imprisonment. Okay, so this is the infringement of patent. So what will be the registration cost for filing a patent means? Suppose if you are going to do the offline mode means the cost will be around 4,300. For filing a patent alone, it will be around 4,300. Suppose both filing and examination is required means there you can make a registration fees which is around 8,300. Okay. So for both patent filing and examination. Once you have filed a patent, the examination may come within 6 months of filing your patent. Okay. So suppose if you want to make a product and sell it to the market means you have to definitely you have to go for the examination. So in that examination, you have to present your idea or your prototype, whatever you have, in front of the panel members. Okay. So the panel members will definitely ask you how it will be useful to the society and how it will be useful to the social needs, whether it is related to the medical or any health related issues only. They will provide the granting to your patent. Okay. So once the file is granted, you can develop your product and you can register your own company and you can also sell your product into the market and you can also make a profit of it. Okay, so basic things, suppose if you want to start a business, okay, for selling your product, okay, first you have to file your product, okay, after that only you can go for the company registration, okay, once the registration is done, then you can go for selling your product, okay. So the starting phase will be filing a patent and granting a patent. Once all the processes are over, then you can go for the company registration. Okay, the basic thing is to industrial is industrial property rights. Okay, suppose if you have a book, if you have content, if you are going to write a novel, or if you are going to write any kind of stories. Okay, first you have to make a copyright. Okay, after that only, okay, you can sell it into the market. Okay, so all the things are coming under the intellectual property rights. So the final conclusion is, I already told you that intellectual property rights is very much required. Those who want to do some kind of business or any kind of startup company, product selling, or any kind of marketing or advertisement purpose, definitely IP is required. IP registration is required. Okay. So generally, it will encourage the creation of large variety of intellectual goods, and you can also make a more incentive for the creation. You can make a profit of it by selling a product from your own intellect. Okay, that is the advantage of IP registration and IP production. So this is my conclusion. So I hope I have covered the overview of intellectual property rights and different categories of property rights and how to do the patent searching, okay, and what are the registration fees and the infringement of a patent. Okay, so just I gave a glimpse of the intellectual property right. Now, if you have any queries or any doubts, you feel free to ask me. Any queries? Any queries on intellectual property rights? Queries இருக்கமா? Okay. இருக்கமா?
Sir, so I think they don't have queries.
Shall we wind up?
Yes, sir. Yes, sir. Thank you for the session, sir. We got some idea about how we are got some pattern and how to do the registration and all things. Very thank you so much for your session, sir. Thank you so much.
Thank you.
Atuli, I can start, ma.
Yes, ma'am. So, a very good morning to all. I feel very honored to give the vote of thanks for this wonderful session. First of all, I would like to thank the management for giving the opportunity to organize such an event. I also convey my special thanks to the resource person, Dr. S. Gopinath sir, for sharing the wonderful information and bunch of knowledges with us. I also thank all the coordinators of the session. Last but not the least, I also thank all the participants of the session who made this session a very grand success. Thank you.
Thank you, sir.
Thank you.
Yes, sir. Students, you can leave the meeting, ma.